We'll hear argument this morning in consolidated cases, number 13354, Sebelius, Secretary of Health and Human Services versus Hobby Lobby Stores, and 13356, Conestoga Wood Specialties Corporation versus Sebelius. Mr. Clement.
Mr. Chief Justice, and may it please the Court, when a federal government agency compelled employers to provide something as religiously sensitive as contraception, it knew that free exercise and RFRA claims would soon follow. In particular, the agency itself provided exemptions and accommodations for the religious exercise of a subset.
Is your claim limited to sensitive materials like contraceptives, or does it include items like blood transfusion, vaccines, for some religions, products made of pork? Is any claim under your theory that has a religious basis, could an employer preclude the use of those items as well?
Well, Justice Sotomayor, the first step in the analysis would be to ask whether or not there's a substantial burden on religious exercise. I do think this case is, in a sense, easier than most of the examples that you've brought up, because here's one where it's so religiously sensitive, so fraught with religious controversy, that the agency itself provides a certain number of exemptions and accommodations. So that's one way I think that you'd address the first step of the question.
Well, just take one of the things that Justice Sotomayor asked about, which is vaccinations, because there are many people who have religious objections to vaccinations. So suppose an employer does and refuses to fund or wants not to fund vaccinations for her employees. What happens then?
Well, if we assume we get past the substantial burden step of the analysis, then the next step of the analysis is the compelling interest and least restrictive alternatives analysis. And every case would have to be analyzed on its own. I do think in the context of vaccinations, the government may have a stronger compelling interest than it does in this context, because there are notions of herd immunity and the like that give the government a particularly compelling interest in trying to maximize
blood
the number
transfusions?
The blood transfusions, again, each one of these cases I think would have to be evaluated on its own and apply the compelling interest, least restrictive alternative test and the substantial
burden. So really every
test.
Medical treatment, and Justice Sotomayor is quite right, that there are quite a number of medical treatments that different religious groups object to. So one religious group could opt out of this and another religious group could opt out of that, and everything would be piecemeal and nothing would be uniform.
Well, Justice Kagan, nothing could be clearer than when Congress passed RFRA, Congress made a judgment that RFRA was going to apply to all manner of federal statutes. And I think what Congress...
Mr. Clement, maybe it seemed clear then, but since RFRA, just as before RFRA, Congress has continued to write into federal legislation specific religious exemptions for some, but not everybody, for individuals, sometimes religious institutions. So if it was all that clear that RFRA took care of it all, why did Congress continue after RFRA to pass these laws focusing the exemption on an individual religious institution? Well, those, as I take your argument, all of those laws, and there are more than half a dozen, were unnecessary. Once RFRA was on the books, Congress didn't have to do that anymore.
Well, Justice Ginsburg, I'm not sure that they were all unnecessary. And, of course, in a variety of contexts, Congress may proceed on a belt and suspenders matters. So I think there's really two different questions. One is, when Congress passed RFRA, was RFRA just done with creating other exemptions? And I think the answer to that is no. But I think the question that Justice Kagan's question brought up is, was Congress evident, and did Congress specifically consider whether RFRA would apply across the board to all the provisions of 18 U.S.C., or rather all the provisions of the United States Code? And Congress could not have been clearer that it was passing a statute that it wanted to apply to all pre-existing statutes and to all subsequent statutes unless Congress specifically provided otherwise.
You were beginning by giving us a framework for your argument. Do I think of this as a statutory case? Of course, the First Amendment is on the stage at some point here. But I take it you can prevail just on the question of statutory interpretation. And if that is so, are there any statutory rules that work in your favor, that is to say, avoiding a constitutional question? Or how do we think about this case? Primarily as a statutory case?
Obviously, one of my clients has before you right now a free exercise claim, and my other client has a free exercise claim that's live in the lower courts. So those issues are preserved. But I think, as your question points out, this Court really, first and foremost, can decide this on the basis of the federal statute. And the Ashwander principles of constitutional avoidance seem like they would be sort of fully applicable to the Court's consideration of that question. And then, of course, the normal principles of statutory construction would certainly point you to the answer to the first objection the government raises, which is, do persons include for-profit corporations?
But, Mr. Clement, isn't this a special kind of statute? Because this is a statute that specifically refers back to a body of constitutional law. It basically says we want to get right back to the place that we were with respect to religious claims before Employment Division v. Smith. And so we have it's a statute that directs us to a body of constitutional law. That body of constitutional law is, I think, very different from the one you portray in your brief. It suggests that accommodations should be made sometimes, but rarely, and subject to a balancing analysis, not to a compelling interest standard in the way we would use it for, say, race discrimination. So, what's the response to that?
Well, first, Justice Kagan, let me take a little bit of an issue with your premise, and let me try to be responsive to your question anyways after I do that. How I'd like to take issue with your premise is that when Congress first passed the statute, RFRA, it talked about free exercise as defined in the Court's cases. And then at the time that it passed RLUIPA, which is a later statute, it actually confronted some lower court cases that had limited RFRA and tried to impose a centrality requirement. And Congress didn't want that. It didn't want to take all the baggage of the pre-Smith free exercise cases. So it actually amended the statute to broaden it so it now protects any exercise of religion. So I would take issue with your premise that RFRA simply picks up everything that ever happened pre-Smith.
Well, there's another respect in which this, even as originally enacted, does not track the pre-Employment Division versus Smith law. That is to say, the compelling state interest test in the prior cases was never accompanied by a least restrictive alternative requirement. That was an invention of this law.
I think that's fair, Justice Scalia. One of the things that you run into if you try to sort of get at this statute the way that Justice Kagan is suggesting is that not everybody exactly agreed as to what the pre-Smith case law was. You described the pre-Smith case law, in your opinion, in a certain way. Justice O'Connor described the pre-Smith case law in another way. So it's a little bit difficult to try to say, as Justice Kagan's question would suggest, that rather than just apply the statute as written, we should really sort of just go back and apply pre-Smith law as if...
Well, it is applying the statute as written. The statute as written, this is not a question of legislative history. The statute as written points back to pre-Smith law. It says that's what we mean.
Well, you're right, Justice Kagan. In the purpose part of the statute, it says what we mean to do here is basically restore the pre-Smith law. But it also accompanies that purpose statute with operative language. And the operative language, which I think this Court should apply, as Justice Scalia suggests, applies broadly to any exercise of religion by any person, and then suggests that the relevant test is substantial burden with the burden on my client as to the substantial burden part of the test.
This was a law that was passed overwhelmingly, both houses of Congress. People from all sides of the political spectrum voted for it. It seems strange that there would have been that tremendous uniformity if it means what you said it means, to take to cover profit corporations, especially in light of there was an effort to adopt a conscience amendment, a specific conscience amendment in 2012, and the Senate rejected that. That amendment would have enabled secular employers and insurance providers to deny coverage on the basis of religious beliefs or moral convictions. It was specifically geared to secular employers and insurance providers, and that was rejected.
Well, Justice Ginsburg, I would suggest to the contrary. The reason that there was such unanimity behind RFRA in the first place is that efforts to limit it to just certain subclasses, subsets of religious freedom claims were rejected. And sort of everybody in Congress got together and said, all right, you have some claims that you actually want to be vindicated. You have some claims you want to be vindicated. We'll vindicate all of them. And if we're going to look at any legislative history as shedding light on this, then I would suggest you look at Professor Laycock's brief, which goes into great detail about the legislative debates involved that led up ultimately to the passage of RLUIPA. And when Congress was trying to pass a broader statute, the RLPA, the Religious Liberty Protection Act, the issue of the statute's application and RFRA's application to for-profit corporations was squarely put at issue by the Nadler Amendment, and that amendment was rejected. And the House report that demonstrates the rejection of that amendment could not be clearer that they understood that for-profit corporations would be covered. Now, in fairness, what they understood is that we were probably talking about, in the real world, a relatively small set of corporations, like an incorporated kosher market or kosher deli of the kind that this Court had before it in the Crown Kosher case. And so I think it's, we can talk about the extent and how you'd apply these principles to Exxon, but I think that's just something that's not going to happen in the real world. It is no accident that the claims that you have before you in these cases are brought by small, closely held corporations that have firmly held religious beliefs.
But again, Mr. Clement, as Justice Ginsburg said, this was a very uncontroversial law. Your understanding of this law, your interpretation of it, would essentially subject the entire U.S. Code to the highest test in constitutional law, to a compelling interest standard. So another employer comes in, and that employer says, I have a religious objection to sex discrimination laws. And then another employer comes in, I have a religious objection to minimum wage laws. And then another, family leave. And then another, child labor laws. And all of that is subject to the exact same test, which you say is this unbelievably high test, the compelling interest standard with the least restrictive alternative.
Well, I don't say that. I think Congress said that. But to be as responsive as I can to your question, the parade of horribles that the government offers you ought to sound familiar. Because if you look at that parade of horribles, Social Security, minimum wage, discrimination laws, compelled vaccination, every item on that list was included in Justice Scalia's opinion for the Court in Smith. And Justice O'Connor responded to that in her separate opinion, and she said, look, you got to trust the courts. Just because free exercise claims are being brought doesn't mean that the courts can't separate the sheep from the goats.
Well, now, that's because she had an understanding of how the Court worked pre-Smith that was a kind of Sherbert v. Werner Yoder understanding, which was we did a balancing. We looked at the government's interests. We took those very seriously, especially to the extent that there was harm to identifiable third parties and that it fell on an identifiable third party. That was basically you could not get an accommodation for that kind of harm.
Well, what she said, and whatever the merits of it is a matter of a constitutional debate, isn't relevant. What I think is relevant is that Congress clearly preferred one side of that debate and thought courts could handle this. So then the question becomes, how do courts actually apply this test? And I don't think applying the test to recognize this case, where I think the government has an incredibly weak case on compelling interest and least restrictive alternatives, which they almost don't want to talk about at all, is going to endanger any other statutes. And if I could talk about specific—
Well, could I ask you this, Mr. Clement? In all the years since RFRA has been on the books, have any of these claims involving minimum wage, for example, been brought, and have they succeeded?
Justice Alito, very few of these claims have been brought. Very few of them have succeeded. And that's notwithstanding the fact that all of these statutes we're talking about apply to employers generally. And none of those claims have been brought or they haven't succeeded, notwithstanding the fact that the government concedes that sole proprietorships and partnerships and nonprofit corporations are all protected by RFRA. Now, millions of Americans are employed by proprietorships, partnerships, and nonprofits. So if these statutes really were on a collision course, I think we would have seen the collision already.
Well, with respect, Mr. Clement, I think that that's probably because the Court has had a different understanding of what RFRA does and the kind of analysis that it requires courts to perform than you're arguing for in this case. That if your argument were adopted and there was a strict scrutiny standard of the kind that usually applies and a least restrictive alternative requirement, then you would see religious objectors come out of the woodwork with respect to all of these laws. And because you say and I think this is absolutely right when you say it, that you cannot test the centrality of a belief to a religion. You cannot test the sincerity of religion. I think a court would be, their hands would be bound when faced with all these challenges if your standard applies.
Well, Justice Kagan, a couple of thoughts. First of all, it's not like this Court has never had a RFRA case that had applied the standard on the merits. And in the Ocentro case, this Court applied something that very much felt to the government at the time as being strict scrutiny. But
it was a religious organization.
It certainly was a religious organization, and it's a separate question.
And this is what's different. All along the earlier cases dealt with individuals, and they dealt with religious institutions.
Well, if I may, Justice Ginsburg, there's two separate questions. There's the questions about how to apply the test, if it's applicable in a particular case, and I think Ocentro is the starting place for guidance on that. Your question also brings up the separate question about the coverage of the statute. And as to that, I think the place to start is the statute itself, which broadly provides coverages to persons. That is not an incidental term. It's a term that picks up additional context through the Dictionary Act and specifically applies to all corporations, to joint partnerships, to societies.
How does a corporation exercise religion? I know how it speaks, and we have, according to our jurisprudence, 200 years of corporations speaking in its own interest. But where are the cases that show that a corporation exercises religion?
Well, Justice Sotomayor, those cases, I'd start with cases like Lukumi or Ocentro, which all involved corporations. And nobody thought it was particularly problematic there that the plaintiffs before the court were artificial entities. And I suppose you could take...
Well, but they were really arguing about things that affected their membership, not them as a corporate entity.
Well, I'm not sure that you can so easily divide the two, and we can talk about how it is with corporations generally. You understand how the corporation has certain beliefs or certain intent, a scienter requirement. The courts every day deal with issues of trying to figure out what kind of intent or motivation a corporate entity has.
The dissent in this case, in the Tenth Circuit case, said, how do we determine when a corporation has that belief? Who says it? The majority of shareholders, the corporate officers, is it 51%? What happens to the minority? And how much of the business has to be dedicated to religion? 5%, 10%, 90%? Well, let's assume not a business like yours. You picked great plaintiffs, but let's assume just a business that sells 5% of religious books, doesn't play Christmas music, doesn't works on Sunday, does nothing else religiously.
Right. And Justice Sotomayor, I think the way to approach those cases would be the same basic way you approach other questions of corporate intent or corporate motivation. You look to the governance doctrines, if any of this is put at issue. And I think that's really a critical question, which is ultimately I think this line of questioning goes to a question of sincerity. And if some large corporation asserts some claim that's going to save them lots of money, I would think that the government in those kind of cases is really going to resist the sincerity piece of the analysis. In this kind
That's
of case,
the most dangerous piece.
Well,
that's the one we've resisted in all our exercise jurisprudence, to measure the depth of someone's religious beliefs.
To be clear, this Court's cases have always distinguished between the sincerity inquiry, which the Court has allowed, and the centrality inquiry, which is suggested as inappropriate. But sincerity has always been a part of this Court's cases.
I thought more importantly was whether a burden was substantial or not, that we've never acceded to the person claiming a religious exemption, a belief in how substantial the burden might be.
Right. This Court has not questioned that. The Thomas case, I think, puts us common ground with the idea that you don't really second-guess the person's the person's belief, but you can contest sincerity. There's case law on this. You have people who are arrested in possession of large quantities of marijuana, and they assert that they belong to the Church of Marijuana. And those cases do get litigated, and they get rejected. And there's a lot of different ways to
Is there a different way of looking at it, the leeway? in U.S. versus Lee, we said when followers of a particular sect enter into a commercial activity as a matter of choice, the limits they accept on their own conduct as a matter of conscience and faith are not to be superimposed on the statutory schemes which are binding on others in that activity. So isn't that really the answer, that we've never considered a for-profit corporation as exercising religion?
Well, let me take on Lee first. And, I mean, that's obviously the two lines of Lee that are the government's favorite two lines in Lee. But Lee starts with a substantial burden inquiry, which is where most of these sincerity questions go. And Lee definitely says that there is a sincere religious belief and a substantial burden on religious exercise. So the two sentences that you're quoting come in the compelling interest analysis of the case. And I think Lee does stand for the proposition that in the tax context, it's going to be very hard for somebody to bring a claim that satisfies even the demanding compelling interest.
That's an interesting question, because the briefs on both sides here are written as if the penalty for not having a health insurance policy that covers contraceptives is at issue. But isn't there another choice nobody talks about, which is paying the tax, which is a lot less than a penalty and a lot less than the cost of health insurance at all? These employers could choose not to give health insurance and pay not that high a penalty, not that high a tax.
Well, just to put this in concrete terms, for Hobby Lobby, for example, the choice is between paying a $475 million per year penalty and paying a $26 million per year
No, I don't think that's
coverage.
the same thing, Mr. Clement. There's one penalty that is if the employer continues to provide health insurance without this part of the coverage. But Hobby Lobby could choose not to provide health insurance at all. And in that case, Hobby Lobby would pay $2,000 per employee, which is less than Hobby Lobby probably pays to provide insurance to its employees. So there's a choice here. It's not even a penalty in the language of the statute. It's a payment or a tax. There's a choice. And so the question is, why is there a substantial burden at all?
Well, just to be clear, we were talking about the same thing. So the option, the choice, is between paying a $475 million a year penalty and a $26 million a year penalty. That's what Hobby Lobby faces. So
the choice between paying $2,000 per employee per year if Hobby Lobby does not
that's $26 million.
Hobby Lobby is paying something right now for the coverage. It's less than what Hobby Lobby is paying for the coverage. There are employers all over the United States that are doing this voluntarily because they think that it's less.
I thought that part of the religious commitment of the owners was to provide health care for its employees.
That is true, Mr. Chief Justice. It is also true that this
If they want to do that, they can just pay a greater salary and let the employees go in on the exchange.
Exactly, which is, by the way, why comparing the $2,000 penalty to the cost of the health care is a false
It's not called a penalty,
comparison.
it's called a tax. And it's calibrated, He's
right about that.
Yes. And it has been treated for some purposes as a penalty. And I think for this purposes, it certainly feels punitive. And if I could finish the thought about why it's a false comparison, the $2,000 penalty to the cost of the health insurance, is that it's going to very much hurt Hobby Lobby if all of a sudden it doesn't provide health care to its employees. And in order to compensate for that, it would have to increase the wages. And I think it would be worse off as a result of this. But if I could
let's say that that's right. Let's say that they have to increase the wages a little bit. I mean, still, we're talking about pretty equivalent numbers. Maybe it's a little bit less, maybe it's a little bit more, but this is not the kind of thing that's going to drive a person out of business. It's not prohibitive. It's like the thing that we talked about in Braunfeld, where we said, maybe if the store can't stay open 7 days a week, it makes a little bit less money. But so be it, is what we said.
No, I actually think what it's like, Your Honor, with all due respect, is like the $5 penalty enforcing the prohibition in Yoder. And what this Court say is it's one thing if you don't have a direct government prohibition on a religious exercise or a mandate that somebody do something that violates their religion. In those cases, which is like Sherbert and it's like Braunfeld, then you have to look at the substantial pressure and it becomes a little bit more of a loosey-goosey analysis. But when you have a government law that specifically says you must do something that violates your religion and it's enforced with a penalty, and with all due respect, I think $2,000 per employee is a penalty.
But Mr. Clement, it's not saying you must do something that violates your religion. It's giving you a choice. You can do this thing, or if this thing violates your religion, you can do another thing. And that other thing is approximately the same price as the thing that you don't want to do.
I don't think it would be the same price at the end of the day. I'd also like to point out how this —
Well, of course it wouldn't be the same price at the end of the day. If they deny health insurance, they're going to have to raise wages if they're going to get employees.
Absolutely.
It's absurd to say that it comes out of nowhere.
Absolutely, Your Honor. And this, by the way, this $2,000 penalty is very much a double-edged sword for the government.
But
because if you're trying to —
Why is that a problem? Let's assume that the cost of providing insurance is roughly equivalent to the $2,000 penalty. How is the employer hurt? He can just raise the wages.
May I just put a footnote on this? I thought the average price of providing insurance for a single person is $4,000, and it's $12,000 for a family. So the $2,000 tax, that's what it's called, is to help the government provide subsidies to people on the exchange that don't have employer insurance. So it's a tax because it is to do exactly what your client wants, to get the government to supply the contraceptives, not the insurance companies.
Here's the problem with this way of looking at it, which is to say whatever it costs per employee to get this health care, that's something that right now Hobby Lobby is paying whatever it's paying them, plus it's imputed into that is the idea that they're getting their wage and they're getting health care insurance. If they take away the health care insurance, they are going to have to increase the wages to make up for that, and they're going to have to pay the $2,000 penalty on top of it, plus they're going to have to violate their own interest, which is we believe it's important to provide our employees with qualifying health care.
The last is important, but just assume hypothetically that it's a wash, that the employer would be in about the same position if he paid the penalty and the employee went out and got their insurance, and that the employee's wages were raised slightly, and that it's a wash so far as the employer is concerned, other than the employer's religious objection, just on the financial standpoint. Can we assume that as a hypothetical? Then what would your case be?
I think my case would be that in that case the government might be able to sort of support itself on the compelling interest. I think there would still be a substantial burden on their exercise. But again, this all turns on issues that the government hasn't put in issue. This case hasn't been litigated on this particular theory. So I think I'd love to have the opportunity to show how by not providing health insurance, it would have a huge burden on my client and their ability to attract workers, and that in fact would cost them much more out of pocket.
But
that's not been the nature of
the
theory.
There was a point made earlier, and I think you didn't mean to say this. The provision of health care is not part of their religious belief. Covering their employees for health care, that is not a religious tenet, right?
No, it actually is. Again, it hasn't been the principal theory on which this case has been litigated. But if you go back to the complaints and you go back to our briefs, as part of the religious beliefs that both the Hans and the Greens have, they think it's actually important.
But, Mr. Clement, you're not saying, are you, that their religious beliefs mandate them to provide health care? I thought that you were never making that claim.
I didn't have to make that claim in the course of this litigation. What I'm pointing out, though, is for purposes of the substantial burden analysis, it is perfectly appropriate to take into account that the $26 million in fines they would pay would not be the only thing that they would lose out if they are on that horn of the dilemma. They would also lose out all the additional wages they would have to pay, and they would be in this position of not offering health care, which is something they believe is important for their religion as well.
I'm sure they seem like very good employers, and I'm sure they want to be good employers. But, again, that's a different thing than saying that their religious beliefs mandate them to provide health insurance. Because here, Congress has said that the health insurance that they're providing is not adequate. It's not the full package.
Well, with respect, what Congress has said is that this kind of plan is not appropriate for a non-grandfathered plan. But if we're going to talk about the government's compelling interests here, which I think has got to be part of the analysis, then I think the grandfathered provisions of this statute really are devastating for the government's argument that it has a compelling interest. When the government pursues compelling interest, it demands immediate compliance. It doesn't say get around to it whenever it's convenient. I can't imagine Congress passing Title VII and saying stop discriminating on the basis of race, unless, of course, you have a pre-existing policy that discriminates on the basis of race, and then you can keep it as long as you'd like. It is fundamentally inconsistent with a compelling interest analysis.
Well, but I think
to have
even,
this kind of
even that example, initially Title VII did not apply to any employers with fewer than 25 employees. And then gradually Congress brought the number down because Congress realized that there were going to be transition issues and that some time was needed to make sure that the compelling interest, should be applied uniformly across all employers.
Here's respectfully why I don't think that works, which is I think the question whenever there are exemptions in a statute is to ask yourself, do the exemptions undermine the compelling interest that the government asserts? There's nothing inconsistent with an interest in prohibiting employment discrimination to say we're going to focus on the people who actually employ the most people and therefore could engage in the most discrimination. It's quite a different matter, and I don't think anybody would think that Congress would pass a Title VII that said, hey, as long as you have a pre-existing discriminatory policy, you're allowed to keep it. That doesn't seem like
your
something that would be
attorney,
consistent.
One of the attorneys below, on behalf of your clients, admitted that the grandfathered policies weren't going to be around very long because any change to an existing policy, and he said these changes happen on a yearly basis, and we already know from the government statistics that it's up to 40%. Now have grandfathered out. Your own client changed its policy, and that's why it's not grandfathered. And he changed it to drop contraceptives it was covering.
Well,
and so my point is, since when does a transitions grandfathered exemption, and one that everybody knows will have to change, because premiums, by definition, will change or co-pays will change. Something's going to change. It's a very short transition period. Since when does that prove that the need is not compelling?
With all due respect, it's not necessarily a very short transition period, and your references to co-pays and premiums is precisely on point because the government, through its regulations, has allowed grandfathered plans to make changes to the co-pays as long as they're indexed to medical inflation. Now, if you have a transition period that's just there for a nanosecond, you don't bother indexing it to medical inflation. So this is a grandfather provision that's going to be around for multiple years, and by the government's own numbers, tens of millions of employees are not getting this mandated coverage as a result of the grandfathered provision. And even if we can project forward 10 years to when maybe there will only be a handful of grandfathered plans, even at that point, you would still have the same problem that the government would have, which is it has to make an argument for a compelling interest.
Just before your time starts to go too fast, how would you suggest that we think about the position and the rights of the employees? And you can have hypotheticals about the employer wants to make them wear burqas and so forth. That's not in this case. But in a way, the employees are in a position where the government, through its health care plans, is under your view, is allowing the employer to put the employee in a disadvantageous position. The employee may not agree with these religious beliefs of the employer. Does the religious beliefs just trump? Is that the way it works?
Well, no, it's not just the way it works, Justice Kennedy. I actually have 4 things I'd like to say about that, if it's possible. One is, I think the first thing about third-party burdens is you have to ask where are they coming from. And if the third-party burdens are coming from an employer, an employer right now can put some burden on their rights because they have to listen to religious music or whatever, that's not as serious as a burden that's coming directly from the government. So that's one principle to think about. Another principle, and this is more of a detail, but I think it's important, is that to the extent you take into account third-party burdens, you take take those into account in the compelling interest part of the analysis. The government has an argument that somehow third-party interests go into the substantial burden part of the analysis where we bear the burden, and we don't think that's right at all.
But, Mr. Clement, you made the analogy to RLUIPA, and the one thing that has not been mentioned up till now is the Establishment Clause. The Court was very clear when it came to RLUIPA, which you said is similar to RFRA, that the accommodation must be measured so it doesn't override other significant interests. And that was true of Sherbert, and that was true of Yoder. And the Cutter case in this Court made it very clear that the accommodation has to be balanced, and you have to take into account other significant interests.
Right, but that actually brings me to my third point, which is those other significant interests that carry the most weight have to be independent of the very statute that's at issue in the case and that the party seeks an exemption from. So if you think about the Caldor case, there the Court was concerned with the third-party burdens on, say, an employee who had a seniority right to take the weekends off. So he or she had an independent right to take the weekend off, and the government policy was coming in and displacing this.
I'm not sure that squares with Lee. The statute created the right to Social Security, and there the Court said you can't deprive employees of a statutory right because of your religious beliefs. Lee is contrary to the point you're making.
There, too, I have to respectfully disagree, because if you remember the facts of Lee, Lee is brought not just by the employer but by the employee. So the particular employees there don't have a beef with what he's doing at all. And I think when they're talking about third-party burdens there, what the Court's really talking about is the burdens of everybody else who contributes into a system where uniformity, to use the Court's words, was indispensable. And so if I could, though, I think just to illustrate why it's sort of double counting to count the mandated issue here as being what gives the burden to the third party or the benefit on the third party, imagine two hypotheticals. One is Congress passes a statute and says, I have to destroy all of my books, including my Bibles. Another statute, Congress comes in and say, I have to give all of my books, including all of my Bibles, to you. Now, in the second case, I suppose you could say that a RFRA claim somehow gets rid of your statutory entitlement to my Bibles. But I don't think, since it's the very benefit that we're talking about that's at issue there, I think that really is double counting. And I don't think those two hypothetical statutes should be analyzed any differently. The other thing, though, about burdens, and I think that should go into this is a fourth point, that should go into the compelling interest test.
Isn't that just a way of saying that you think that this isn't a good statute because it asks one person to subsidize another person? But Congress has made a judgment, and Congress has given a statutory entitlement, and that entitlement is to women and includes contraceptive coverage. And when the employer says, no, I don't want to give that, that woman is quite directly, quite tangibly harmed.
Well, Justice Kagan, I think you could say the same thing about my Bible hypothetical, but I do have one last thing to say about burdens. And I do think when you think about impacts on third parties, not all of these burdens are created equal. And that, too, I think is borne out in this Court's cases. And the most relevant factor is there some alternative way for the government to ameliorate the burden? And I think about two types of kind of accommodations, if you will. You get sort of Title VII with a very narrow accommodation. And then you have conscience clauses that allow medical providers, including for-profit medical providers, not to provide abortions. Now, each of those has a burden on third parties, but I would respectfully suggest they're different. In the case of the employee who's been subject to racial discrimination, even if they can get another job, that racial discrimination is a unique injury to them that you can't remedy unless you tell the employer, don't discriminate on the basis of race. Now, in the context of the conscience clause, if a woman can't get an abortion from her preferred provider, that's surely a significant burden on her, but we don't view that as trumping the conscience clause because she can get the abortion through another mechanism. Here, as your question rightfully highlights, all we're really talking about is who's going to pay for a subsidy that the government prefers. This is not about access to the contraception. It's about who's going to pay for the government's preferred subsidy. And I think in that context, there are ample alternative ways to address any burdens on third parties. And that goes right
into the least. It would make no difference if it were there are 20 FDA-approved contraceptives, all of them covered by the Health Care Act.
I think
you picked out, in one case, 3, and in the other case, 4. Suppose the employer says, contraceptives altogether are against my religion, so I'm not going to give any contraceptive coverage.
Well, obviously, Justice Ginsburg, I didn't pick these out. I mean, my clients and their religious beliefs identified these as problematic.
Yeah, but your argument, it seems to me, would apply just as well if the employer said no contraceptives.
I think that's a fair point, Justice Ginsburg, and the government's own accommodations where they offer them to religious groups and religious employers like nonprofit hospitals also applies to whatever the religious beliefs of that provider are. So if they extend to all 20, then the exemptions apply to all 20. If they only extend to 4, then the exemption applies to all 4.
Are there ways of accommodating the interests of the women who may want these particular drugs or devices without imposing a substantial burden on the employer who has a religious objection to it?
There are ample less restrictive alternatives, Your Honor, and I think they all flow from this fact that this is ultimately about who's going to pay for the subsidy.
Those are alternatives that you're asking the government to incur or the person to incur.
Well,
I mean, there isn't an alternative that doesn't put a cost on someone else.
Well, it's funny about this particular mandate because the government's position is this is actually a cost-free mandate, that whatever you pay out in contraceptions, you're going to make up and not having to pay for other coverages. And so one alternative, one less restrictive alternative, is what's done in the accommodation for nonprofit employers like hospitals, where basically they tell the insurance carrier or the plan administrator that you pick up the cost for this, and then essentially it'll be cost-neutral from you. But I don't think there's anything sort of sacrosanct, if you will, about having the government pay for its preferred subsidy as a less restrictive alternative. And that's essentially what the government does for those employees who have employers under 50 employers. If those employees, if the employer doesn't provide health care, those employees go on to the exchanges with a subsidy from the government. Now, they could do the same thing for objecting religious employers. They just have chosen not to. If I may reserve my time.